opinion comes from Susan P. Waters on a motion to dismiss. She rejected the motion outright, saying that neither of Metcalfe's arguments have any merit, which all the other folks who have read the Constitution and are well versed in the Bruin decision seem to disagree. First, she said that the Montana law doesn't meet the requirements of the Gun-Free School Zone Act and scrapped it completely. As for the constitutionality argument, the law has already been found unconstitutional before, which was a point that I have brought up in every video that I've talked about this case, and I saw in a lot of the comments. But here's where it gets tricky, legally speaking. Bill Clinton and Janet Reno turned around and added 12 words to the law to try and appease the courts. 5 circuits have upheld the law based on that addition, while 3 have continued to say it doesn't pass constitutional muster. The Ninth Circuit is one of those that have already upheld the law, saying that it falls under the Commerce Clause. This decision was before Heller and before Bruin, but it seems that Waters doesn't care. Bruin requires historical analogs. The prosecution supplied some 19th century laws that banned students from having guns on campus, which is not a good fit, remotely. The judge rightly did not consider that sufficient, so apparently she went through the historical record herself. The only thing she could come up with was a law from the Constitution of Delaware in 1776 that banned guns within 1 mile of polling places for 24 hours before an election to 24 hours after it ended. So like 2 days. Well, actually, let me backtrack, because it turns out that that isn't accurate either. She said that the law banned guns, but a reading of the law states it banned battalions or companies on the state payroll and not individuals, which does not give me any more confidence in her ruling than I already had. If you don't believe me, here it is, straight from the source, Article 28. Article 28, to prevent any violence or force being used at the said elections, no person shall come armed to any of them, and no muster of the militia shall be made on that day, nor shall any battalion or company give in their votes immediately succeeding each other, if any other voter who offers to vote objects thereto.